think of all the people that annoyed you in high school that were the hall monitors and the people whose greatest desire was to be on city council, student council. Those are the people who run administrative agencies, and we do not want those people in charge of your life.
We are the Armed Attorneys. Today we're talking everyone's favorite SCOTUS term, Chevron Deference, with the Loper Bright Enterprises v. Raimondo case. Is it Raimondo?
Yeah, the current Secretary of Commerce.
Yeah, news to me. But if you want to check this out, this is SCOTUS Docket number 22451. But before we begin, show your support for the Second Amendment by hitting that like button. And today's video is brought to you by friends at Sonoran Desert Institute. Check them out, sdi.edu/armed-attorneys. Learn about online gunsmithing and so much more, sdi.edu/armed-attorneys. We have had a lot of discussions about Chevron deference over the past couple of years. That's one of those words that has entered the sphere of the community. Chevron deference standard comes from a 1984 case. Has really led to a huge administrative overreach. Tell us about the world before Chevron deference.
Well, the Chevron case came out in 1984, which, just seeing the letters 1984 together always takes me back to the halcyon days of high school when life was wonderful. It was also in the middle of the Reagan administration, which this is one of the cases. Yeah, I've seen, well, this came down the Reagan. Keep in mind that a Supreme Court usually does not have the characteristics of its presidency, because in 1984, the Supreme Court was still dominated by a very liberal wing of the court that had Thurgood Marshall, William Brennan, Blackmun, Stevens. In fact, I believe Stevens wrote the opinion. And so these people were all New Dealers or had come from the New Deal philosophy where they were going to give total deference to the administrative agencies. The administrative agencies were basically another branch of the government. They had autonomy. And basically what it said was, if Congress passes a statute, and number one, that statute contains an ambiguity, then deference should be given to the administrative agencies, which supposedly were made up of industry people and experts who knew how to interpret this statute better than the courts did. And so that's
Insert clip of Emily saying how much rat poison can be in her cereal.
I don't need my favorite congressman, who is maybe an attorney by trade, to tell me how much rat poison is allowed to be in my food. That's not his specialty, right? I want people who study how much rat poison I can eat without, getting seriously ill, to tell me how much rat poison can be in my food.
That's the thing. Whenever people want to see the destruction of the administrative state, like I do, and the tearing away regulations, then people always go to, oh, well, we're going to have poison food and we're going to have unsafe workspaces. And
Sure.
that's just simply not true. The administrative state has grown beyond the scope of what it was intended to be. Think of all the people that annoyed you in high school that were the hall monitors and the people whose greatest desire was to be on city council, student council, the people who basically wanted to run your life and tell you what to do. Those are the people who run administrative agencies, and we do not want those people in charge of your life. So the Chevron deference now has been in effect since 1984. We're dealing with 40 years worth of administrative agencies being able to basically do whatever they want, write their own rules, interpret their own rules. That's the world we've been living in. However, their world may be coming to an end. And why is that?
Well, we have this, incredibly offensive case that was decided out of the DC circuit. We have a handful of commercial fisher industry actors who filed an action against the Department of Commerce, NOAA, Marine Fishery Services, and a whole bunch of their administrators, alleging that they implemented this final rule that essentially it has these industry-funded monitoring programs, and they're saying that these violated a long list of different federal laws. But this thing, this is a good case to look at because it is so burdensome and so out of control that whenever the Supreme Court of the United States looks at this, remember how we've said in the past, bad facts make bad law. These are good facts, crazy, outrageous facts. Maybe we get something out of it. But essentially, it would force the industry to pay for its own fishing monitors, saying, hey, you got to put these folks up in a cabin on your boats. These people are going to be monitoring you. They're going to be measuring these fish. They're going to make sure you don't overfish. You have to pay their salaries. And the court even estimated that the entire cost of administering this, again, this is a rule, this isn't a law, could be as much as 20% of revenue for these fishermen. So, I mean, outrageous facts. Now, the DC Circuit said it's ambiguous. Congress did not provide clear rules when it came to who pays for these fishing observers, and so therefore we're going to give it to all of these agencies. We're going to leave it to their discretion. Chevron deference all day. And then the Supreme Court of the United States decided, all right, we have this petition for certiorari. They granted that, so we're going to hear this in the next term.
In the event that it rules in the favor of the fishermen and not in the favor of the administrative agency, NOAA, how is this going to affect the ABC agencies that have an impact on the rights of gun stores, gun owners, gun manufacturers? Of course, we're talking about the FBI, the ATF, Homeland Security. How's it going to affect those groups' abilities to affect our lives and business?
We'll have it linked in the description below to get to the Supreme Court kind of filing section. And we'll also link to one of the briefs that I think we should talk about. We have nearly 50 different groups, all affected by different administrative agencies saying, hey, we want to weigh in on this, and we want to weigh in on Chevron deference. Notably Gun Owners of America, Gun Owners Foundation, Heller Foundation. I mean, there's a whole bunch of firearms groups. I mean, we could list all of them. But you see across industries, a lot of different folks saying, hey, we need to get in here and mess around. I think it comes down to kind of, I'd say, a couple of different points. But from my perspective, Congress should be the person regulating. We should not be delegating this authority to administrative agencies. And so I think a lot of folks have problems with that. And this is probably kind of a little bit of bad news bears for the ATF. For the most part, they're administering criminal laws, which we use a slightly different standard. What is that?
The rule of lenity, which says that whenever you're at risk of going to prison for violating the law, with regard to the fisheries, they're obviously they're incurring expenses. Maybe they have new regulations, but at the end of the day, the chief threat against them is not prison. Whereas with firearms crimes, your chief threat is prison. And so when you're at risk of losing your liberty in terms of going to prison, you do get a little bit more of an advantage by having this looked at through the rule of lenity, which says that the courts are supposed to side on the side of the defendant, not on the side of the state.
And so the context that it would come up in for the ATF is, let's say they decided to arbitrarily start imposing taxes on firearms, ammunition, parts, things like that, or things that might effectively look like a tax. Chevron deference would have a big say there. I do think Chevron is a good argument, and it can come up whenever they pass these rules and try to redefine something that Congress has, clearly defined. So obviously we don't have ambiguity there. So I think it does hold them back a little bit. But again, we got to keep in the back of our minds, we're talking about the rule of lenity for the most part when it comes to the ATF. Now, I'd say the last kind of big argument that we see for maybe ditching Chevron is that essentially we are delegating a ton of power to effectively the executive branch of government. Instead of saying, law should come from the Congress, but they're giving it all up and essentially handing it over to the executive branch. We have this giant, I would say, misalignment when it comes to the separation of powers.
Yeah, and of course we're seeing that now because we have an administration which is clearly hostile to the Second Amendment, clearly hostile to gun owners, and so you have an ATF that basically had been quiet for more than a decade suddenly come out with their frames and receiver rule, their force reset trigger rule, their arm brace rule,
bump stocks,
the bump stocks, and so this is what this all comes from a very powerful executive. Now, one of the unintended consequences that we may see that we may not like is that if Congress is forced to act and if there is pressure from the gun control lobby, will Congress be more apt to pass a law that restricts gun rights? Because obviously when Congress passes, what we want is we want Congress to be deadlocked. We want Congress to be stalemated. I know the mainstream media says, oh, this is just a terrible thing. That's because they don't understand history. They don't understand American government, because the way that the system is set up, it's supposed to be deadlocked, because whenever it's not deadlocked, that's when people's liberties get taken away.
Yeah, that's when we get the Bipartisan Safer Communities Act. Thank you, Trader John Cornyn. But we look at that, I think that's still, I think that's a good consideration. We all need to keep that in the back of our heads. I think a good thing to come out of it though is, when Congress acts out of line, thankfully there's a remedy for it. We vote those people out of office. Whereas, like, how do I vote some bureaucrat who's been there for 30 years out of office? I mean, come on.
Oh yeah, no. Bureaucrats are terrible people. So anybody in our audience, if you're a bureaucrat,
You're the good one. We like
present
you. You're
company
great.
excluded. But by and large, bureaucrats are terrible. Like they said, they're the people who in high school wanted to run your life. And so we don't want those people in power. And you're right, we do have a remedy through the ballot box, which we just want to remind all of our viewers that elections have consequences. It's more important now more than ever that you get out and you vote your political interests when it comes to your Second Amendment rights. And even though they may not be threatened, you want to make sure that the person you're voting for is a staunch Second Amendment supporter.
Yeah. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video. What do y'all think? Do you think this is going to be the big SCOTUS case next term? Do you think it's the Rahimi case? I want to hear what y'all have to say down in the questions section down below. And until next time, we're the Armed Attorneys.